Welcome to Once Upon a Case, because the law isn't just for lawyers, it's for everyone. Okay, let me take you back to 1971. Picture this: a quiet farmhouse in Iowa, endless fields, and a legal case that would spark debate for decades. This is the story of Katko v. Briney. It all starts with the Brineys. They owned an old farmhouse that kept getting broken into again and again. Frustrated, they decided to set a trap. Not just any trap, an actual spring-loaded shotgun, rigged to go off if anyone opened the bedroom door. Enter Marvin Katko. One night, Katko broke into the farmhouse, likely looking for antiques, maybe just being nosy. He opens the bedroom door, and boom. The gun goes off, and he's seriously injured. Now you might be thinking, serves him right, he was trespassing. But the law doesn't always work that way. Katko sued the Brineys for his injuries, arguing that even though he was trespassing, he shouldn't have been met with deadly force. Here's the big question: do you have the right to defend your property with something as dangerous as a shotgun trap? The answer, according to the court, was a big no. The court said you can't use deadly force to protect property unless your own life, or someone else's, is in immediate danger. In other words, stuff isn't worth someone's life, even if they're breaking the law. So what happened? The jury awarded Katko damages, money for his injuries, even though he was breaking and entering. The case became famous not just for its wild facts, but for the principle it set. Katko v. Briney is still taught in law schools all over the US. It's a case that makes you question: how far would you go to protect what's yours? And where's the line between security and safety? The Brineys, for their part, lost their case but made legal history. Their situation reminds us all: sometimes, the law protects even those who break it, to keep us all a little safer in the long run. So next time you think about setting a booby trap, remember, the law is more interested in protecting people than property. That's the story of Katko v. Briney. One farmhouse, one shotgun, and a lesson that's echoed through courtrooms for over 50 years. Thanks for hanging out with me. If you enjoyed this story, don't forget to like and subscribe. Catch you in the next one.